She's laying out the elements of the crime that she has to prove, and then she's giving the jury the evidence that supports that element. I think that's one of the easiest and best ways to go about explaining to jurors what they saw over the course of a trial and why they should convict.
Yeah, what I really like about it, Michael, is that not every summation, if you're a really good trial lawyer, should always be the same. But there are some basic elements that are important, and you've just described them. She's going through the indictment, and she's going through the elements of the offense, as we call them. Often, many lawyers will say it's like the ingredients to building a cake. And she's taking them step by step, methodically, through each aspect of how to bake that cake in order to have the jury feel confident and comfortable in the decision that the defendant is guilty by proof beyond a reasonable doubt. She's going through it in a way also that jurors are likely to go through it. Remember, they don't tell jurors how to go about their deliberations. They basically tell these 12 folks, go in there and deliberate. So she's going through basically giving them a path, if you will, or an outline as to how they should analyze the case, which is just as important as the evidence in the case, too. And that's why when you try a case, last point, Michael, you always think about it from the minute it comes into your office to the minute you're saying thank you very much at the end of the case, always with the summation in mind and building the case by going backwards and having the evidence and the witnesses that can allow you to say what she's saying right now.
Yeah, oftentimes, you would write, or many attorneys, they write their closing argument beforehand and sort of, like you said, work backwards. It tends to work well. Again, you have to have flexibility, of course, but that's the way you start. This defendant chose not to testify. I think overall it was a good choice, but in this instance, I'm wondering your thoughts, because he's claiming that his confession was coerced, right? Okay, so it was coerced. You want me to believe that? I'm a juror, okay, but so get up there and tell me the real story, right? That's the way I would look at it, and he hasn't done that. Do you think that's a problem?
It's very rare that I say this, Michael, but in all the years in the cases, I don't know why this one, at least for me, Bob Bianchi, can't come up with any level of creativity, either as a prosecutor anticipating a defense or as a defense lawyer defending this guy. If you're not going mental health, you're not putting him on the stand to talk about passion, provocation, or any of the typical defenses you would have in a murder case. The idea that, the confession was forced doesn't mean it's not truthful, and that there's not a ton of evidence that supports what was said in the confession anyway. There's not even a Hail Mary pass being made here. It's almost like I'm just going to go through it because I have a right to, which you do. You have a right to a trial. It's almost like you're doing it just for that reason, because there's been no efficacious or worthwhile legal defense presented.